the matter of Nguyen and the Home Department.
Good morning. I appear,
Mr. Symes.
Mr. Symes, good morning to you. I appear for the appellant in this matter. My learned friends, Ms. Smythe and Ms. Jackson, I believe, going to do a piece of the advocacy in due course appear for the Secretary of State, the respondent in this matter. Just to start off with housekeeping issues, I trust the supplementary bundle of authorities has made its way to you now.
Yes.
In electronic and paper form. You'll see that one of those items noted, the last item, is noted on the contents page at the start as being something which is the relevance of which is disputed, and so I should make it clear that its inclusion is not agreed. I mean, it's simply a dictionary definition because the FTT referred to the pocket English dictionary. I simply thought that the court should have access to a more authoritative dictionary if it was going to look at dictionaries at all. So that's the dictionary. Those are the only formalities that I have to deal with. My plan is to, in terms of the structure of my submission, subject to preference by the court, is just to start off by taking a brief look at what the First Tier Tribunal and Upper Tribunal said, though I'm aware that you probably covered that in your pre-reading. Then to take a quick tour through the primary legislative materials and the rules. Then to look at the case law, and then to pick up on any of the respondent arguments that I feel I haven't addressed so far along the way. So to start off with the decision of the First Tier Tribunal, which begins in the core bundle at page 143, a decision of First Tier Tribunal Judge Nguyen. He recites the essential facts of the case towards the beginning of his decision, pages 143 under 144. The important ones really being that the appellant had originally arrived in the UK in June 2003, claimed asylum, loses his appeal. That was received in a false name in 2007, paragraph 4. Convicted following a guilty plea, Canada's production, a 2-year sentence. Court recommended deportation, doesn't bother an appeal. Removed to Vietnam in October 2007. In February 2019, he applied to revoke his deportation order, so more than 10 years after leaving the country. That was refused in December 2020, and he appeals. As you will probably have noticed, there are ultimately 2 sets of appeal proceedings, though one set doesn't really matter very much, and that arises because of the structure of the immigration rules, which 392 says that merely succeeding in having an appeal, the deportation order revoked, does not in itself entitle one's return. One has to make a separate entry clearance application. So one set of proceedings, the less important ones here, are the entry clearance decisions and appeals. The more important one is obviously the revocation proceedings. Anyway, so the judge goes on and summarises the legal provisions, and then materially, really, page 150, his paragraph 37, refers to a dictionary definition. And the Taylor House First Tier Tribunal Library has to hand a copy of the English dictionary one, which is that the noun form support means remove forcibly or exile to another country or banish. Paragraph 38, the judge notes that for a person who's already left the UK, the act of forcing them to leave the country has already happened. And so an application to come back appears not to be covered by section 117C. And then he looks at 2 other factors. It's paragraph 40. He looks at the language of section 117C and finds that it is in general prospective. And then he looks at the decision of the Court of Appeal, is paragraph 41, the EY of Turkey, noting that section 117C had not been considered in that Court of Appeal authority, which was so the First Tier Tribunal judge infers was that it indicated that's because it didn't apply, even though that was a deportation So that was the brief survey of the facts and the thinking of the first tier tribunal judge. And then he decides in paragraph 43 then that the Home Office applied the incorrect threshold in her decision, and paragraphs 44 and 45 he just raises various points from the original revocation decision letter, which he says was essentially shows that the Secretary of State was wrongly looking at a regime which was forward-looking, essentially. And his paragraph 46, he notes that there's no consideration of the passage of time since the appellant had left the United Kingdom and is thus his compliance with the deportation regime. So having noted those perceived flaws in the Home Office approach to the case, the First Tier Tribunal judge then goes on to review the facts and apply his understanding of the law to them. So paragraph 49, having just noted a 2-year prison sentence and a court-recommended deportation, he observes that the appellant had been producing cannabis on his account to make money to support his family because he couldn't legally work. He was resourceful, he had no other convictions, and he had never offended since. Yes, paragraph 50 observes that there's no possible chance of future reoffending given that the appellant and his family were now financially secure. Directs himself to the fact that there are different aspects of the public interest when considering criminality, not only reoffending he thinks it was mainly at 50, at 51 he notes that on the authorities he must also look at deterrence and public concern. But again in 51 he says that the time spent abroad would be a significant answer to any issues of those nature. So far the appellant has spent a lot of time abroad, which was surely a deterrent, and that presumably anyone who looks at this would see that the appellant had suffered and been separated from his family for many years, and therefore the public concern issue was also addressed. Paragraph 52, he then weighs up those public interests against the impact on the appellant's family life. The appellant's wife and adult son have been in the UK consistently since the appellant's departure. They had spent some time together abroad. He acknowledges there's no issue of financial vulnerability. The appellant had other more extended family back in Vietnam and his own house. Paragraph 53, he refers to all these factors, including the adult son's problems of growing up in a single-parent household, as the sad but justified consequences of the need to support foreign criminals. He notes that the appellant's son is an adult, married, expecting a son in his own right, and therefore implies that he's an independent family unit. Paragraph 55 notes that the son, as well as the appellant's wife, are British citizens now. They would remain in the UK if they had to for the foreseeable future if the appellant could not join them. Paragraph 56, he notes none of this is very compelling, and that the deportation of the appellant has been unduly harsh within the meaning of section 117C. Not unduly harsh. It's quite clear that the First Tier Tribunal judge would have dismissed this appeal had he been driven to apply those tests as he understood them under harsh and very compelling. But he directs himself that, in fact, he must look at the deportation and revocation rules, which is paragraph 56, citing the rule there that looks at the scope of the relevant considerations, and then he goes through them. Paragraph 58, he reminds himself of the public interest criminality points he's already addressed. 59, directs himself to the representations made on behalf of the appellant. Paragraph 60, the community interests, effective immigration control, he says, isn't in play because the appellant complied with the deportation order, didn't even try and fight it originally, and has stayed outside the UK for a long time. And so he finds that there are no public interest points really as irrelevant, and one public interest point he does a light on is that people should be encouraged to comply with the deportation regime on the basis that they might one day be allowed to come back. Then at paragraph 61 and 62, he goes on to note the Court of Appeal authority of TZ and PG, which is the one that says that where the rules are satisfied, so long as family and private life is engaged, then the satisfaction of the rules implies that the immigration decision to refuse would be disproportionate. So he finds that having surveyed the deportation revocation rules and found them to come down in the appellant's favour, that is determinative of the human rights appeal. So that was the approach of the first tier tribunal. And then the Upper Tribunal decision, which is the subject of this appeal, is at page 89 onwards of the court bundle. And by now, Upper Tribunal Judge Norton Taylor has efficiently linked the entry clearance appeal and the revocation deportation appeal into a single set of proceedings. Very succinctly summarise the facts of the case and notes paragraph 7 on page 92 just summarises the decision already made on error of law. It's a very succinct decision that proceeded by agreement, which is why I moved direct to the remaking decision. Benarku was treated by this Upper Tribunal as essentially determinative of the issues, and that was without cavil on this record who appeared below, as you can see at paragraph 8. For the reasons I've already noted, at his paragraph 9, now Judge Norton Taylor observes that Judge Branham below would have come to a different conclusion on Judge Branham's understanding of very compelling circumstances, and therefore this was a material error of law, and the Upper Tribunal goes very much to determine matters for itself. So going on a few pages, page 99, paragraph 34 onwards, it looks first at the question of undue harshness. Noting that the couple have lived apart for a long time, the appellant's wife has seen his son grow up alone on a daily basis. But nevertheless, paragraph 35 finds that she's in good health, has adapted to life without him, able to have contact remote by modern means of communication, and is maintaining what he calls a reasonable life in the UK, and so therefore it wasn't unduly harsh for the UK family to stay here without the appellant. In terms of whether or not it was unduly harsh for them to go abroad, he also finds 36 to 38 that it wouldn't be unduly harsh for them to relocate, essentially because it had the advantage of being with the appellant, would be familiar with Vietnamese society and culture, would know the language, no significant health issues. But he concludes that both on the go, as well as the stayed scenarios, it wouldn't be unduly harsh to relocate. Then he moves on to the residual issue, 117C6, paragraph 41 onwards, and directs himself to a very compelling circumstances test is self-evidently a difficult one to satisfy. Looks at all the circumstances, paragraph 42 looks at the public interest, that's per 117C1. 43 notes lengthy separation of the appellant from his wife and son. He says it's to be given limited weight because there's always some split of the family unit countenanced by effectuating deportation. There'd always be some period of time before the reunion via return to the UK. They've been able to maintain their contact abroad. Paragraph 44, he gives very little weight indeed to honouring the deportation order, as it were. He says it's not really a matter of doing the right thing because leaving the UK is to be expected, following which you can only be readmitted to the UK via a successful revocation application. And he's quite clear, understandably given his error of law decision, paragraph 44, an appeal against the refusal of revoke engages the stringent tests imposed by section 117C, and having already failed to meet those, having failed to meet the undue harsh thresholds within 117C, he finds that the appellant cannot meet the very compelling circumstances, even on even aggregating all the points so far made. Getting on a bit to paragraph 47, he notes that the appellant satisfies most of the requirements of Appendix FM, i.e. that's a shorthand way of saying that the appellant would, given he's in a genuine relationship and there's enough money behind the scenes, and given the family generally speak English, would satisfy the bespoke family partner route under Appendix FM to the immigration rules.
May I just interrupt Mr. Simon, please, and ask you a question about the passage in brackets at the end of paragraph 47. Is it right to say that the suitability requirement is tied up with the successful appeal 1? Because even if appeal 1 were successful, the deportation order would be revoked, the appellant would still have a criminal conviction.
That is true, and I suppose a conviction at the range between 1 and 4 years is taken particularly seriously.
It must be surely, because the only impact of revoking a deportation order is to remove the statutory inhibition on applying for entry clearance. That's all it does. You then have the application for entry clearance, which is looked at on its own merits, and you can't ignore one of the factors that is relevant, which is that you've been subject to a criminal conviction. I think that's the right answer, Mr. Simon.
Yes, I mean, I think that's something I'd be grateful to have a chance to come back with it later, because I've opened Appendix FM and just taken one look at it, and it seems to be the kind of thing that I'm not going to be able to engage with in a matter of seconds. I'll make a note to come back on that in due course.
What do we have before us? Do we have the entry clearance appeal before us, or is it just the revocation question?
You do, because Upper Tribunal Judge Norton Taylor aggregated, he consolidated the two appeals in the Upper Tribunal.
And this is an appeal against the remaking decision, or an appeal against both the error of law and the remaking decision?
Well, I suppose actually we've only challenged
The remaking decision.
we've only challenged we're challenging the Upper Tribunal remaking decision.
But you need to challenge the error of law, because it's the error of law decision which says that the first tribunal got it wrong by not applying section 117.
Well, the difficulty with the challenging of the error of law decision is that the point appears to have been conceded, as is recorded in the judgment.
Well, I mean, we accept that. I mean, there's some stuff we're fixed with the historical events below. I mean, it's my case that, as for all the arguments ventilated in the Skeleton argument and the grounds of appeal, the appellants.
Paragraph 8, it was accepted that the judge had erred. It was contended that the error was immaterial. Judge Norton Taylor didn't accept that, went on to do the remaking. So either Judge Norton Taylor got it wrong, or there's a bit of a problem.
Well, I mean, I accept that Mr. Record conceded the applicability of the section 117 regime below, but I mean that's the issue which is in contention in our submission on this appeal. And all our arguments, the whole of our ground 1 is focused on demonstrating that that concession was wrong. And the appellant shouldn't be prejudiced by a concession that was wrong. So yes, the entire force of our first ground appeal and is working out in the skeleton is predicated on is challenging the error of law decision. Yes, Judge Nguyen Norton Taylor's error of law decision, essentially, when he finds that section 117C regime is in play, and therefore Judge Brannan was wrong not to take back, not to.
Well, are you
Well, sorry,
challenging?
because you just I'm so sorry, Simon, I'm now very confused.
Yes.
A moment ago you said you weren't challenging the error of law decision, and you were just challenging the remaking decision. And now you seem to be saying you are challenging the error of law decision, so I'd just like to understand which
Let's have a look at the grounds of appeal and we'll be able to find out, as the appellant's noted, which decision is being. The only decision that is under challenge in this court is the decision of Upper Tribunal Judge Morton Taylor.
Yes,
Page
you
4.
made two decisions.
Well, whichever. But it's certain. Oh, right, yes.
He made the error of law decision, and then he made a remaking. So,
Right, page 6. The decision promulgated on the 8th of March whereby he set aside and remade. It's all one, but he didn't.
well, let's just have a look at the date of the determination.
Law decision.
So the error of law determination was promulgated on the 12th of December 23,
So that's not under charge.
and remaking was promulgated on
4th of March 24.
8th of
8th of March 24. It's got a different date on the end of it. It was promulgated in the end. So you're challenging the remaking.
Yes, but I had rather read the remaking decision as is the style of the Upper Tribunal, as wrapping up within itself its own earlier error of law decision, which is why it summarises it at.
No, they're distinct.
7:10.
So if you haven't challenged the error of law decision, you're restricted to challenges to the remaking decision. And it may be that you can run an argument in relation to the remaking decision that the tribunal misdirected itself, but different issues may arise if that's the issue, the decision was being challenged rather than the error of law decision. Provisionally, anyway.
I understand where the court is coming from here. I hadn't really conceptualised it in quite that way, because ultimately I'd seen it that the Upper Tribunal in its remaking decision had applied the full Section 117C regime, and that was the matter which we were challenging, whether or not one saw its spring in the error of law regime, error of law decision.
Yes, but it makes a difference, because if if you're not able to challenge the Upper Tribunal's decision to set aside the decision of the FTT, the focus of this course is going to be on whether the Upper Tribunal was in law, not on whether the Upper Tribunal was entitled to set aside the decision of the FTT, because you haven't challenged that decision.
It doesn't shut you out, of course, from arguing that the Upper Tribunal judge was wrong to apply Section 117C.
Exactly, that's still an issue.
That's still very much an issue, but it does make a difference potentially to the disposal, depending which way we decide to appeal.
Yes, I understand that. Okay, well, we've given those issues an airing, and I'll deal with it. I'll deal with it.
Well, it's a very confusing procedural picture, which is why we're asking you the questions, because speaking for myself, I'm very confused about where we all are. So thank you very much.
Well, I propose now going to my mainstream submissions on Section 117's its applicability anyway, and then perhaps a little later in the day we can pick up on what the thinking just speculated means for that analysis.
Yeah.
Right then, so now we'll move to the authorities manual. And I'll go through the legislation in rational order. So starting at tab 2. Is everyone on paper on the or
Yes, but my bundles are both about to collapse, so you may have to wait for me to try and repair them. Tab 2.
so tab
Also,
2.
I have no tabs, so if you could be kind enough to give me the page numbers, that would be helpful. Thank you.
Yes, indeed. So
Page 10, 2002 Act, yes.
done on the 71 Act. So I'll just give you the page, don't forget tabs, then I'll just give you pages.
Right.
Page 4, 004.
Yeah.
So, section 3, subsection 5 establishes the foundation of the deportation power. Persons not a British citizen liable to deportation from the UK if Secretary of State deems deportation to be conducive to the public good. That's our situation, 35A. Moving down to 3.6. Without prejudice to the operation of subsection 5, also liable to deportation if, having attained the age of 17, convicted in an offence punishable by imprisonment, and on his conviction is recommended for deportation by a court empowered by the Act to do so.
Yeah.
So 3.6 applies on these facts.
Yes, we have 3.6,
Yeah.
we have court recommended deportation. Then page 8 deals with procedure for and further provisions as to deportation, section 5.1. Essentially, this sets out procedure for deportation. 5.1 says Secretary of State may make a deportation order against him, that's to say, an order requiring him to leave and prohibiting him from entering the United Kingdom, and that order invalidates any leave so far in force. 5.2, and this is the authority for revocation. Deportation order against a person may at any time be revoked by a further order of the Secretary of State. So those are the foundational provisions for deportation orders and their revocation. The next provisions in technological order are the 2007 Act, which begins at page 22. And this explains that a foreign criminal, section 32(1), is someone who's not British and convicted in an offence, and to whom one of two conditions applies, and relevant here it's 32(2), sentence to a period of imprisonment for at least 12 months.
This wasn't in force at the relevant time.
Indeed, you're right. I mean, I'm going to this for the general scheme. I'm going to
Yes.
the general scheme of regime. You're right. You're quite right. This wasn't in force at the time of the original expulsion of the appellant.
When did it come into force?
I believe 1st August 2008.
Which was in 2007.
Yes. And section 33 explains that when a deportation application is made, so section 32.6, section 32.6, Secretary of State may not revoke a deportation order made in accordance with section 5, which is what requires deportation orders to be made, unless he thinks an exception under section 33 applies, or revocation is made whilst the foreign criminal is outside the UK, or section 34.4 applies. 34.4 simply refers to granting leave or making a new deportation decision, so not anything clearly here. But the general regime is such that applications of revocation made while someone is abroad are made under 34.6b.
So 32.6 doesn't apply in this case because the deportation order in this case was not made under this regime.
Yes, that's correct. Right. And then, as is well known, section 33 of the 2007 Act sets up the system of exceptions, including 33(2)(a), which is convention rights. And then leaving the 2007 Act and going to the 2002 Act as amended in 2014, 117A to C. So 117A is in the bundle, page 15. It applies where courts or tribunals are required to determine decisions made under the Immigration Act breach Article 8 rights. That would be, as a result, would be unlawful under Section 6 HRA 1998. 117A2, in considering the public interest question, the court or tribunal must in particular have regard to considerations listed in Section B and 2B, in cases concerning the deportation of foreign criminals, to the considerations listed in Section 117C. Then we can move on to Section 117C, which is page 18.
Before we do that, is this a case concerning the deportation of foreign criminals?
Well, it's my submission that it isn't, because the provisions of 117A and 117C read together are forward-looking. So it isn't a case. So a revocation of deportation where the appellant is abroad is different.
Although revocation comes within all the provisions relating to deportation.
But also, this part introduced by subsection 1 of 117A, this part applies where a court or tribunal is required to determine whether a decision made under the Immigration Act breaches a person's right to a family life in or under the HRA. Considering the public interest question, the tribunal must in particular have regard. Blah blah blah. So, is it really right that Part 5A doesn't apply to a decision to deport somebody? Because it's a decision made under the Immigration Act, and the issue is whether it breaches Article 8.
Decision to revoke.
Yeah, sorry, the decision to revoke.
Well, so my case really is that the language of Section 117C, when we see it at the moment, is forward-looking, and that has to.
No, I understand that argument. What I'm asking you about first of all is whether Part 5A applies to a case like this or not. What's your submission?
In general, Part 5A aside from 117C, I would accept does apply, because this is a decision made under the Immigration Act inevitably, and it turns on private and family life considerations.
Yeah, all right, that's helpful. Thank you very much. I'm trying to work this out for myself as we get along. So it's just helpful for me to be able to take in stages. Thank you.
And then we get to 117C. And we see that 117C1, the deportation of foreign criminals, is in the public interest. 117C2, more serious offence greater the public interest in deportation. 117C3 introduces the two exceptions, exception 1 and exception 2. Exception 1 is the private life one, 117C4. 3 components: lawful UK residence for most of your life, social and cultural integration, and finally, very significant obstacles to integration into the country to which C is proposed to be deported. And that's one of my examples of future-looking language. Then 117C5, the family life exception, looks at genuine subsisting relationship with a qualifying partner or parental relationship with a qualifying child, and the effect of C's deportation on the partner or child would be unduly harsh. Again, in my submission, the centre of gravity of that language is forward-looking. 6 is that it's the very compelling circumstance over and above undue harshness proviso, and subsection 7 concentrates the mind of the decision of the judge reviewing the case on the actual decisions being relied on by the Secretary of State to deport. In the refusal or revocation, in the refusal letter, and it's phrased considering a decision to deport a foreign criminal, which again in my submission is forward-looking. So, you know, I hold fast to the proposition that 117C seems to be looking at future events rather than past ones.
Do you accept that 117C would apply if an application for revocation was made and refused at a stage at which the deportation had not happened?
Yes, indeed. I would accept that. Yes.
So it's not the fact that it's a revocation decision which stops 117C applying, it's the fact that it's a revocation decision after the deportation has happened.
After the deportation has been effected, yes. And so we're looking
A post-removal revocation.
indeed. And I would say that would be consistent with the scheme of the 2007 Act, which, whilst not controlling of this appeal because of the decision dates, had previously differentiated between expressly deportation generally and revocation applications made from abroad. Right. So now I propose leaving the legislation and moving to the rules. Now, we thought it would be useful to provide you with multiple iterations of the rules, not in any way to be difficult or confusing, but because obviously different cases that we may look at refer to different iterations of these rules.
Is there any dispute as to which rules apply in this case?
Well, the first tier tribunal decision was 22nd of June 2022. So that judge was applying the fourth iteration of the rules, those effective from the 20th of June 2022.
Should he have been applying those rules or the rules in force at the time that it was decided by the Secretary of State?
Well, there's Court of Appeal Authority, it's tab 11 YM Uganda. I think this is agreed. I don't think we need to turn it up, which is that it's the rules in force at the date of hearing in a human rights appeal
By the FTT.
Yeah, which was controlled.
So those are the rules that the FTT should have and did apply?
Yes.
20th of June 22.
Yes, indeed, as I understand it. Those are the rules that should have applied and did apply.
Can I just ask if there's any dispute about that?
Well, I'm not sure that is right. What I would say is this, because it's something that certainly was in my mind. The fact is that to the extent that there were any differences between the rules as at the date of the Secretary of State's decision and the rules in force as at the date of the first tier tribunal's decision, there's no material difference. That's
So
the
it
other.
doesn't matter.
Yes, the other point is also that what this court has said, and in fact the Supreme Court, is that in a case like this, assuming that Section 117 applies, the tribunal doesn't really need to worry about the immigration rules at all. So in that sense, it falls away. The reason that the first tier brought the rules in is because of its, we say, mistaken decision.
Well, I understand that, that's a
so
different
that's-
point. But,
but
if the rules do apply, do you dispute that it's the 20th of June 2022 rules we should be looking at?
My submission would be that the normal position is it the rules at the date of the Secretary of State's decision.
That's what I
But
thought.
there is no material difference, as I understand it, between the version that the court has at tab 8 and the version in place at the date of the Secretary of State's decision. I'm happy to have a word with my learned friend just to understand what paragraph it is in YM Uganda that he relies on in that respect. There was quite a lot of complexity when the new rules came in to do with transitional provisions and so on. But the standard position is it's the rules as at the date of the decision.
Thank you.
But it's academic in a sense. Does that? I hope I haven't misrepresented the position. My learned friend will no doubt say
No,
so.
I thought first I thought the law was that in a deportation case, it was a in a human rights deportation case, it was the rules at the date of hearing that applied, and I thought we agreed that. Now I understand that the second is not agreed, but it doesn't matter. And the first is something. Well, look, I don't. I'll have to think about that a little bit more. There's something I'll pick up.
Yeah, I mean, if you were able to have a discussion and reach an agreed position, that would be really helpful.
We will, and I will certainly check with those instructing me as
Sure.
well.
Thank you.
Right. So going to page 59 onwards.
It may well be, sorry to throw a spanner in the works, but it may well be that because YM Uganda was an Article 8 case, sometimes when the rules are trying to enact the jurisprudence of Strasbourg, of course, once you get round any policy arrangements and make sure that the Secretary of State follows her own policy or her own rules, when you get into the balancing exercise, it may well be that insofar as the rules have encapsulated the up-to-date Strasbourg jurisprudence, that the decision maker would then apply those rules because it is a reflection of how one looks at Article 8 at that time. So it may well be that you're both right in that you would normally apply the laws at the date of the decision under challenge, but when it comes to Article 8 there may be room for slight differences if it's reflecting up-to-date policy. So I mean, I've always been confused by why in Uganda. It's a very, very complicated case. So, we may not need to go there. Sorry to take the rest of that. That may be an explanation.
Anyway, you want us to look at the 22 rules?
Yes, indeed.
Yes.
So, page 6. So materially now, we just want to get within page 62. And we see that 390 essentially addresses the scope of considerations in play in revocation. That's just what first year tribunal ground had looked at. Grounds of the order, representations, community interests, applicant interests. 390A says that where paragraph 398 applies, so it will consider whether paragraph 399 or 39A applies, and if it does not, it will only be in exceptional circumstances of public interest in maintaining the deportation order that way factors. So 390A introduces 399 and 399A, and those paragraphs are essentially the paragraphs of the rules which reflect section 117C.
Yeah.
Okay, so in shorthand, so that's a shorthand way of avoiding too much of the cross-referencing. Now then, 391 says, in the case of a person who has been deported following conviction of a criminal offence, the continuation of deportation order against that person will be the proper course. And it draws a distinction between A and B. A is convictions carrying sentences of under 4 years. B is convictions carrying sentences of 4 years plus. And the distinction it makes is that in the lesser offending cases, the A cases, unless 10 years have elapsed since the making of the deportation order, when if an application for revocation is received, consideration will be given on a case-by-case basis as to whether the deportation order should be maintained. Whereas B, as we just saw, referring to 4 years plus cases, so that's the two. I'm trying to draw the distinction then between the two scenarios. And then in either case, unless in either case, the continuation will be contrary to the ECHR or the Refugee Convention, or there are other exceptional circumstances in which continuation is outweighed by compelling factors. So what this provision seems to say is therefore that if you're an early revocation application, i.e. 391A, and 10 years have not elapsed, you are driven to the ECHR standard or other exceptional circumstances. But the implication is that there is some other regime to be considered, some other considerations, if 10 years have elapsed, i.e. case-by-case basis analysis of whether the deportation order should be maintained. That's 391.
There isn't a rule, is there, that relates to plus 10 years?
Oh no, there isn't. I mean, we don't find anything more than that. What I'm suggesting is that is the that is the rule.
I mean, it's very odd, because you would expect every case to be decided on a case-by-case basis, whether it's 10 years or not. And human rights considerations will always come into play. So it's a bit of a strange rule, this.
Presumably, it's referring back to 390, which says an application will be considered in the light of all circumstances. It sets out particular considerations. But it certainly suggests that you're not limited to breach of convention rights if you're after the 10 years.
Indeed. So that's the legal landscape in terms of the rules. And now I want to take quite a quick look at the case law.
Just before you leave that, I think it's implicit in your submissions that 398, 399, 399A don't apply. Is that right?
Yeah, yes, indeed, yes, because they're the rules which mirror section 117C, let's say.
So it's
Why
the same
don't they
point
apply?
that this is only forward-looking. It doesn't apply to a post-deportation.
That can't be right. You've only got to look at paragraph 398 to see that's not right. A398. These rules apply where B, a foreign criminal applies for a deportation order made against him to be revoked. I thought your point was that these rules weren't in force at the time. As if they were in force, it's squarely within 398. And therefore 399 and 399A come into play, and they mirror 117C, so it's the same point.
Well, as my opponent just remarked, in fact, the rules both before and after, immediately both at the date of decision and the date of the appeal hearing, had a 398 in them.
So what is the answer to 398B?
A398.
A398B on your analysis.
Well, there is a distinction. There remains a distinction as drawn in 391A, which changes the situation where 10 years have elapsed, because only because the Article 8 consideration is called into play in the revocation scenario by 391 final subparagraph, unless in either case the continuation will be contrary to the Human Rights Convention.
But how does 391 affect the application of 390A? 390A says if 398 applies, which it does, the Secretary of State will consider whether 399 or 399A applies. If it doesn't, it's only exceptional circumstances, right? Now that's completely separate from 391. On the face of it, you may say, well, it's qualified in some way by 391.
Well, that is my submission, that the only way to these rules to be fairly read
So
is that there is a
it's
qualification.
qualified by 391.
Might it not be the other way around? Might it not be the case that 391 is as it were setting a baseline, which is that continuation of deportation ought to be the proper cause in a case where sentence was less than 4 years, unless 10 years have elapsed. So in other words, it's saying don't bother applying for revocation unless 10 years have elapsed since the deportation order was made. And then you've got a set of rules explaining how the application for revocation will then be considered. I mean, that's just a provisional view, but that might be one analysis.
that analysis would still have to take on board 391 final subparagraph, unless in either case the continuation will be contrary
Yes,
to human
well,
rights.
of course, yes, that proviso, of course that proviso applies, that clearly applies, but there's then a structured, I think on the Secretary of State's case, there's then a structured series of provisions mirroring Part 5A, which tell the decision maker how to go about deciding an application for revocation once the 10-year period has expired.
I think your case is that these rules 399 and 399A, which as you say reflect section 117C, are only forward-looking, that is, they're only dealing with a case where the individual has not yet been deported, whether that be an application to revoke or not. In other words, when A398B says a foreign criminal applies for deportation to be revoked, your case is that must only apply in the case of a pre-deportation, pre-removal application for revocation, which is what you said about 117C. So that if you're a post-removal application, you'll then be tipped back into 390 and 391 for 10 years and so on. Is that?
Yes, indeed. I mean, the only way, in my submission, we need to cut the Gordian knot. There has to be some assistance, some external entry into proceedings. And 117C, where the language is, if anything, even more forward-looking than these rules, would be the clue in that submission. So the A398 onward regime only applies to past deportations.
I think
you mean future
only
deportations.
applies to deportations that haven't yet taken place.
Yes, indeed, yes. Future deportations, yes. And so now, I propose departing the rules and looking at Z to India, which is the first decision that looks at this regime in general. Now, of course, it's looking at an earlier set of rules, but it's nevertheless looking at a similar scheme of rules. And Lord Justice Underhill brings his experience to bear on the issues. So it's page 108 onwards, his bundle. And he cites the rules 111 onwards. And the rules have similarities, strong similarities, with the rules that govern the current thing that we just looked at, but of course there are differences.
What date are the rules that he was looking at? Which iteration?
As I understand it, he took the date of the first tier tribunal decision, which was 10th of September 2013. So it's the rules. Well, I'm not sure what the rules.
We don't have those. So we just have to take a text from. Yes.
Yes.
Thank you.
There are differences. So one difference is you'll see that at his paragraph 17, when he quotes the rules, they don't have the A398, which we saw a moment ago. And also, if we burrow into them a bit more, we see that it's the language of the Article 8 defining rules, the exception rules, doesn't use the language of undue harshness, it uses the language of reasonableness. So, for example, his paragraph 17, citing his rule 399, we'll see a few lines in. It would not be reasonable to expect the child to leave the UK. And of course, in the rules we're looking at now, the threshold has been upped to undue harshness, not lack of reasonableness. I believe those to be the only two material differences between the rules he's looking at and the ones we're looking at. Anyway, so he analyses these rules. And first point is his paragraph 21. He looks at 390. 390 is the one on scope, remember, the one that said we look at public interest considerations and applicant compassionate circumstances and all that.
I'm so sorry to interrupt. Could you just all of 391 was different as well? Didn't have the case by case wording, so it's on page 111.
Of course, and this is also true. There's a third material difference in that bottom of page 111, where it cites rule 391. 391, you'll remember from a moment ago, is the rule that sets up the potential difference between.
It doesn't have the case by case.
It didn't have the case by case phrase, you see, so it's missing a phrase before the B at the very bottom of page 111.
Still have the split between the 10 years for medium offenders and
Yes.
at any time for serious offenders.
Yes, indeed. So moving on, his paragraph 21, page 113, makes the point that the paragraph 390 of the rules is a provision at a very general level. It doesn't speak to threshold at all. It just gives the range of inquiry. Then 390A, he explains that in broad terms, the effect of this paragraph is evidently to apply the deportation after late regime, but paragraph 398 to 399A, i.e. the section 117C mirroring regime as it was to become in the future. Not only is the initial decision whether to make a deportation order, but also the decision whether to revoke one. Mr. Biggs submitted that that was only so in the case where the applicant for revocation had not yet been deported. Then Mr. Biggs makes his submissions and points out that
Very similar to yours.
yes, indeed, I mean, that's right. They are indeed very much the same thing. And you'll see that Lord Justice Underhill upholds those submissions. And also, he addresses, it was sort of the obiter, because GLD had made submissions, written submissions, because of the confusion that reigned before Lord Justice Underhill. And they made written submissions, and you'll see at the end of his paragraph 22, that he said, I'm not setting out such a paragraph A398, but I should record, at first I would not agree to support the department's submission, even if it had been in force. There's some doubt, obviously he doesn't look at it as fully as he might have done if the matter being fully argued and being enforced, but insofar as he says anything, it suggested that A398 wouldn't change things. Then his paragraph 23, he looks at 391, so he says it's accordingly paragraph 391 and not 390A, which applies in the present case. And ZP India is a case applying for revocation from abroad. And he says, that paragraph states the Secretary of State's policy is the proper length of time for which a deportation order should continue. I in practice the length of time before an application for leave to enter will be entertained. I would refer to this as the prescribed period. In the present case, the prescribed period is 10 years from the date of making of the order, since the respondent was sentenced to less than 4 years imprisonment. Expressly stated not to apply in two distinct circumstances, the convention's exceptions, he calls it, ECHR Refugee Convention, and other exceptional circumstances, which he calls the sweep-up exception. So in my submission, not so long before the current rules regime, there's a judicial analysis from Lord Justice Underhill, which is supported by my submission. He also says in paragraph 24 that he doesn't think that there's a fundamental difference between the two regimes, the 391 regime and the 398 regime. He looks at the 24 at some length. He looks at differences in the language and structure. So basically his conclusion is that there's no real difference, and that the point, the ultimate point, his final sentence, paragraph 24, in striking the balance, decision makers should take as a starting point the Secretary of State's assessment of the public interest reflected in the prescribed periods, and should only order revocation after a lesser period if there are compelling reasons to do so.
So ZP was a case where the applicant had been deported, but had not, 10 years had not elapsed.
Yes, it's an early revocation case. Yes, early application case.
He's saying in that situation, where the prescribed period has not elapsed, even though on his analysis of the rules you're in 391 territory rather than 398 territory, it doesn't make very much difference because you apply the same analysis.
Yes, that's right.
Well, it does beg the question, what happens once you get to the end of the 10 years?
That's what Law 1 goes. So that's what Lord Justice Underhill has to say on this point. And then another case I'd like to look at, which
25, before we leave it, let's
Oh,
talk
good.
about 25 because that has some bearing, doesn't it, on the 10 years.
yes, a passage of time, indeed,
Yeah.
yes.
Well, just as Underhill says, that the public interest in maintaining the order would generally diminish with passage in time. That must be borne in mind in striking the proportionality balance. I set that up to a point. If there are compelling factors in favour of revocation, the case is bound to be stronger if they've already been excluded for a long period, but I would not accept that the passage of time can by itself be relied on as constituting a compelling reason for early revocation. Query what he means by early revocation.
I think he means before the
Before
10
the
Before
10
the
years.
10 years, yes.
Yes, so I understand he's identifying two considerations regarding passage of time. What one is that certainly on itself, it can't get you home in an early revocation application case.
He leaves open the question of whether it's how much weight will I have.
Yes.
But he's not really dealing with the post 10-year revocation case,
No.
is he?
No.
Because the case before him was a pre-10-year revocation case, and the point is, generally, the default is you should serve the entirety of the 10 years. But it just leaves completely unaddressed what happens after the 10 years. But it does suggest that things might change after 10 years.
Yes. I mean, his we didn't turn them all up. According to my own notes to myself, there were 5 passages in his judgment where he's referring to the prescribed period in one form of word or another there. 9, 15, 23, 24, 25. In each of those passages, he's either talking about the term or serving the term or the prescribed period. So the next case I'd like to look at is that of EYF Turkey, which is tab 20, page 273. And this is also an early revocation case, so more time, a bit more time. So you can see it, the head note, page 273, the very opening lines, you can see the phrase, he was deported in 2005, in 2013 applied for deportation order to be revoked. So that's, whereas ZP I think was 3.5 years into his term, EYF is 8 years into his term. So the material reasoning here. So these are the appellant in this case basically submits that there's a strong presumption in favour of revocation after the 10 years. You see that paragraph 15 on page 275. A series of alternative submissions have been made. If not a strong presumption, a presumption arises that after the 10 years, criminal offending cannot justify the continuation of the order beyond the prescribed period. That's the submission by Mr. Shirko appearing to the migrant deportee. And that submission is ultimately roundly rejected
Why was it relevant if you applied within the 10 years?
He tried after 8, didn't he?
Was he submitting that the closer you get to the 10 years, the less weight should, I mean, he said, look, I'm nearly there.
Well, he probably was there by then.
But he was deported, yes, he was deported in September 2005, and the FTT heard his appeal in July 2016.
But the 10 years doesn't run from when he was deported, it runs from when the order was made, doesn't it?
Yes, the order was made in that case slightly early in February 2004.
Might be because the Secretary of State made a supplementary decision on the 29th of March 2016, paragraph 8 at the bottom of page 274, which decision was also taken into account by the first tier, and that would have been beyond the 10-year period.
Yes, thank you, that's very helpful. Anyway, the submission was that after the 10 years, there's a presumption in favour of revocation, and that's not accepted by the Court of Appeal, is it?
No, so paragraph 25 on 277, so I can detect no support for what is advanced by the appellant in the earlier cases. He looks at ZP India, is paragraph 25, emphasises that Lord Justice Underhill had observed that the proposition that the public interest with diminished only time was only accepted for the prescribed period duration. That says nothing about the asserted existence of a new presumption at the end of the prescribed period. It rightly, in my judgment, leaves the question at large. So, EYF indicates that there's an I would say an open balancing exercise.
You just go to paragraph 26 as well.
Oh yeah. He notes that the Strasbourg case law, paragraph 26, doesn't take things any further because the Grand Chamber has said that duration exclusion measures are one factor amongst others. Paragraph 27, he stresses that there's an advantage in taking the plain meaning of the words. As an earlier judge, and I didn't take you to Richard LJ in the SU case because it was very plainly obiter what he was doing in that case. Paragraph 28 says within the 10-year period it would be very difficult for other factors to counterbalance the presumptive effect of the Secretary of State's policy and consistent with the decision of the court in the ZP India case. Once the 10-year period is elapsed, it becomes easier to argue that the balance has shifted in favour of revocation on the facts of a particular case because the presumption has fallen away. But that does not mean that revocation thereafter is automatic or presumed. And he points out that in his view this is consistent with Hisham Ali, his paragraph 29, because final paragraph of his citation, where the Secretary of State has adopted a policy based on a general assessment of proportionality, they should attach considerable weight to that assessment, they being appellate tribunals.
Did anybody in this case argue that section 117C applied? Doesn't seem to be referred to in the judgment, but was then in force, presumably.
It was in force. It was in force, and there's no explanation as to why the court wasn't taken to it, and presumably it wasn't taken to it.
Well, am I right in thinking it's not reflected in the judgment anyway?
It's not, is it?
It's not, my lord, no, and we've tried to find out why, and I'm afraid we haven't got an answer. It's dealt with in paragraph 72 of our skeleton. We say it was in force and it was relevant.
Could be that people just haven't caught up.
Could well be.
When did the amendments come into force? Was it they were made by the Immigration Act of 2014?
I'll check the coming into force date.
I think it's 1st of August 2000.
I think it was August.
And it may well be because of the way the arguments were framed in that case.
Yeah, and there were some transitional provisions about pending things, weren't there?
Yes, there were.
And it may be that because of the transitional provisions, I mean, I just
I have tried to do some digging behind the scenes, but we haven't found an answer as yet.
Thank you.
Anyway, so that's EYF.
Yes, and I would like to take a quick look at the case of SU, also described as ULA. It's reported as SU, so maybe it was on
Yes.
tab 16.
Well, isn't that just the case that says there's a presumption against whilst during the 10-year period?
Yes, but it also
Justice David Richards.
yes.
Recollection. Oh, it came into effect on the 28th of July 2014. One sees it from paragraph 41.
Grateful.
We weren't far out with August, were we?
And this is a case where, the very passage we're looking at, 13 and 14 of the judgment on page 211, quite clear that Part 5A regime, 117A regime, was in the contemplation of the court. But this court nevertheless ultimately finds that a particular immigration rule, 339D, should have been looked at. Even though, of course, that would be in addition to the 117C regime. And we see that, paragraphs 41 to 43. Paragraph 41, it would not appear the judge was aware of 339D, or he referred to it clearly directly. This is a breach case, yeah? We've seen a couple of cases that are early application cases. Now this is a breach case where the migrant has come back in breach of the deportation order, and then there's this rule 399D, which basically says that you need very exceptional circumstances to overcome that behaviour. And so, back to his paragraph 41, it was clearly directly in point to the respondent's case, encapsulates the public interest in ensuring the deportation order is not only implemented, but fully effective. It's not effective if the deportee unlawfully returns to the UK while the order remains in force. It meets a case, like 399D meets a case, not met by paragraph 391, which provided for the unless 10 years have elapsed proviso. And he says it would be odd if this paragraph applied irrespective of the fact that the deportee had returned unlawfully to the UK during the period of 10 years. 43, there was a clear failure to have regard to the applicable paragraphs of the rules. And so here we have a judge finding that an immigration rule that clearly is something that's not in the section 117C regime, and at the same time being cognizant of the section 117C regime, he finds that the rule still has a part to play.
Obviously, there wasn't a complete overlap.
Yes, that's right. He essentially finds that the rules didn't count in the section 117C. Well, his implication, isn't it? His implication is that 117C didn't cater to the situation where they breached the deportation order by making an early returning in the face of it.
Because there is I didn't read, I might be wrong, this is a provisional view, Part 5A as necessarily containing an exhaustive statement of matters that are material in a particular case, and that must be so because there are all sorts of factual wrinkles that such a general ruling can't cater for, and 399D is a specific provision in the rules which does cater for a particular type of case. And you don't get much help from 117C. What you're looking at is somebody who's been deported and then come back and breach the deportation order. other than the very general level, whereas the Secretary of State's made a specific provision catering for that.
Yes, indeed. I mean, my point really is this is a case where this is a statutory appeal
Yeah.
that he's dealing with, and so he actually finds that the provisions in question do. The immigration rule. He finds an immigration rule can have a distinct effect in the general balancing, albeit that it isn't found in 117C.
Yeah.
Which I rely on this because a big part of the government's case today is that 117C is exhaustive and steamrolls over the top of any immigration rules which are not consistent with it, or even not even found within it.
So was this just remind me? Was this a human rights appeal? I mean, i.e., an appeal on human rights grounds only under the 2004 the regime introduced in 2014.
Yes, because it was
I think
there was a refusal in June 2015,
yeah.
and therefore, so by April 2015, everyone was in the modern system.
Yeah.
Forget it was spousal
Paragraph 12. And include that the decision is not in accordance with immigration rules, which is the broader formulation.
Oh, right. So this
That
is
was at the time when that was at a time when that particular provision made a specific. There was a period, wasn't there, when there was a specific provision in legislation that allowed a right of appeal on the grounds that something was not in accordance with the immigration rules.
Yes.
That's gone.
That's gone, yes. But at that time,
But at that time it was there.
Yes.
And so you say that would explain why the court was actually looking to see whether it was or was not in accordance with the rule.
We do say that, yes.
yeah. Well, so thank you for that because I was wanting to understand whether it was just a straightforward human rights appeal or not.
Yes.
So while it's the case that an available ground to appeal with rules as well as human rights, it does seem that the tribunal had approached the matter purely under human rights. Or at least at 34, you see the phrase, the FTT then approached the issue under Article 8 as a separate question from the rules.
Yes.
And this isn't a decision where the court of appeal itself clearly looks at the different grounds of appeals. And of course, it cites Hisham Ali, which is a case where the rules are found to potentially inform the human rights ground of appeal. That's what it said in paragraph 50, page 216. While the rules do not govern the determination of appeals, the policies to which the rules give effect are nevertheless a relevant and important consideration for tribunals determining appeals on convention grounds. So whatever the theoretical jurisdiction that the Court of Appeal was reviewing, it appeared to be looking primarily at human rights issues. Right, so that's the case law I wanted to look at in terms of the sort of points that are most favourable to my case. And now I'm going to come on to the sort of the impediments to the case and the authorities. Before I do so, I want to mention some points, which we might call policy points, as it were. One is that the Section 117C gives no active role to the period spent abroad in compliance with the prescribed period. We've seen that there's a prescribed period clearly identified, of perhaps uncertain import, but it's clearly identified, and 117C is aligned to that. Also in my submission, 117C, at least in the unduly harsh provisions, attributes a fixed weight to the public interest, because in the unduly harsh proviso, only unduly harsh consequences to a child or partner can overcome the public interest. And so in my submission, it would be very difficult to see how 117C therefore could move, could have a flexible public interest on one side of the balance in order to accommodate the proviso in the rules, where we do have government policy, Home Office policy, clearly expressed as recognising some kind of difference after 10 years. Okay, so then the authorities that are against me, there's really a trio of authorities that in a narrow sense are against me, because there's some broad themes in other authorities, but the trio of authorities is IT Jamaica in the Court of Appeal, Williams and Binaku in the Tribunal. So IT Jamaica is tab 13, page 121. This is also this is an early revocation case as well. So this isn't a broad case, but it's an early application, and we can see that from the heading note, page 121. Deported in 2010 and applies for revocation in 2013.
This is after Z2.
Yes, the deportation order was. Well, I could use the actual date for deportation order. I didn't find in this decision. October 2009. October 2009. Deportation decision. So he's applying well within the 10 years after it. And here the court reviews the decision of Justice Underhill and ZP in some detail, but materially, we get to its reasons, page 132, paragraph 50 onwards, and these reasons include that 117C applies. At 50, Lady Justice Arden says, I reached the same conclusion as Underhill LJ did in relation to the provision under which we considered that very compelling reasons have to be shown. I reached that conclusion by the following process. She refers to the case of Uganda, which requires that the public interest be brought into account when assessing the unduly harsh threshold. That was later to be disapproved. I'll give you the reference to that in due course. Her paragraph 52, she says the function of section 117C is to set out the weight to be given to the public interest in the proportionality exercise to be carried out under Article 8. And then critically, she says the word deportation is being used to convey not just the act of removing someone from the jurisdiction, but also the maintaining of the banishment for a given period of time. If this were not so, section 117C would achieve little. She still says at 53 that the tribunal should look at the immigration rules, and she notices the 10-year proviso. So it's quite clear that when earlier she's referring to very compelling circumstances, she's actually referring to that in the context of cases outside of the cases within the prescribed period. But she doesn't have to deal with that. It's not being such a case. 54, she says that 117C2 says the nature of the offending is to be taken into account. That we will also see is problematic given the later Supreme Court decisions. She notes 56 that 117C had been not in force, obviously, at the time of the rules considered in ZP India. But the argument in front of her, as is very clear in 56, also earlier on where the submissions are set out, is focusing on the meaning of the undue harshness test and whether it was different to any predecessor tests in the immigration rules and whether it was the same or different to the very compelling consideration test. So it was a very different focus to the question of whether or not 117C should apply. Obviously, she thought it should apply, but it was determined without argument. But right back at the beginning of the decision, paragraph 2, she'd said it is effectively common ground that under section 117C the deportation order may only be revoked if the detention is determined to be unduly harsh.
Sorry, where did she say that?
Paragraph 2. Page 124.
So there wasn't any argument as to whether section 117C applied, is that right?
Well, not in IT Jamaica, as I understand it. And that wouldn't be surprising, because as an early application, everyone would agree at the outset that they were in the residual bit of the rules, i.e. requiring a compelling threshold or whatever. No one was arguing they were within the post 10-year scenario, which might have led to a lighter threshold.
So it didn't matter whether you were applying section 117C or 398 and 399, because they both refer to unduly harsh, isn't it?
Essentially, yes. So obviously, Lady Justice Arden's judgment is an authority which is potentially against me. But firstly, it's reduced by the lack of adversarial argument. And secondly, it makes two mistakes as to collateral issues. And we see that because of the criticism made of it in KA Nigeria. KA Nigeria is page 251, material passage is 251 of the authorities bundle, paragraph 42. And this is actually this isn't criticism in the context of another case. This is actually onwards appeal in the Supreme Court, as IT was one of the participants in those proceedings. Paragraph 42 on page 251, then we see that Mr. Gravel criticises the forced introduction of a compelling reasons test not found in the relevant subsection. I agree that for that reason at least the Court of Appeal's reasoning cannot stand. So that's because Lady Justice Arden had used the language we saw a few minutes ago of very compelling, when in fact she should only have been looking at undue harshness, the lower threshold within 117C, i.e. meeting the exception within 117C as opposed to being in the residual very compelling considerations bracket. And also though, Lord Carnworth says the first tier tribunal could not be criticised for not applying a test which was not relevant for vision. The reason I've given, I also think it was wrong to proceed on the basis that 117C2 required the nature of the offending to be taken into account. And that's because the Uganda was the case that said the nature of the offending should be considered when measuring whether or not the impact on the child, etc., was unduly harsh. So actually two mistakes in assessing the public interest that are identified in IT Jamaica on appeal to the Supreme Court. In my submission, that makes it a fairly unpromising authority to rely on.
Not particularly material mistakes, though. One's following a case which has been now disapproved by the Supreme Court. It really goes to the heart of the reasoning, do they?
Well, possibly not. I would really say that it's not encouraging, bearing in mind that the reasoning was without the benefit of argument.
It might be said to be a bit of a jury point. I mean, either the critical piece of the reasoning is good or it isn't. I don't think you can say it's contaminated by adjacent reasoning that isn't so good. Anyway.
Before we, and we have sort of departed IT Jamaica to look at the criticism of it in Kenya, Nigeria, but before we finally depart IT Jamaica, I just remind you that what we were looking at in its paragraph 52. The judge, so Lady Justice Arden said, final sentence of paragraph 52, The word deportation is being used to convey not just the act of removing someone from the jurisdiction, but also the maintaining of the banishment for a given period of time. If this were not so, section 117C1 would achieve little. Well, I'd remind the tribunal, is always the centre point of my whole submission, is actually that there is a controlling measure within the rules which says there's a different approach after 10 years abroad. So the point she's making there is the revolving door point made by Underhill. If one could escape the public policy reasons for deportation the moment one left the country and applied for revocation, that would obviously be absurd. That was the context of his points about only accepting the passage of time as relevant so far. And so I would say that actually, on the substantive reasoning about Justice Ardy, she's failed to take account of that important point of the rules. She was alive to that issue in the rules because he mentions it in paragraph 53, but she doesn't take it on board in basically suggesting that section 117C would achieve little if you couldn't maintain the banishment this departure. Right, and then there are the tribunal cases against me, which are...
But just before you leave
Of
that,
course, yes.
I don't quite understand how that works. Which plainly says in 52 and 53 that there is a period, let's look at the rules, it's 10 years, and you're expected to maintain the banishment for that period. But what happens after the end of that period? According to the view that section 117C does apply, section 117C, as you pointed out, contains no recognition that things change after 10 years. So does she think that section 117C only applies for 10 years and then ceases to apply, or what? Don't you know?
I don't know. I mean, it'd be good to get all these judges together in a seminar, maybe. I don't know how.
She didn't need to decide any of that because the application for revocation was so early. She was being
That's reality, because as noted, this is an early application case.
very early.
She doesn't have to look at it.
Okay, thank you.
Right, yeah, so Smith is at page 436. I didn't. The case I'm trying to look at are Williams and Benarku, not Smith and Williams, Williams and Benarku. So I can want to be at 448 to see Williams. And you actually see the head nose of 448 of Williams, which very clearly holds that the 117C regime is in force. At 2, practice such as has been deported does not mean he or she is thereby able to avoid the application of considerations listed in section 117C.
And this is a presidential panel information.
It is indeed, yes.
Yeah.
So in this decision, paragraph 19 onwards, there's a discussion of ZP India in the context of the immigration rules, and IT Jamaica, before too long, is noted. The passage reported Lady Justice Arden at paragraph 52, paragraph 24. This decision at 455 is noted about the weight setting function of section 117C. At 26, this presidential panel considers itself bound by IT Jamaica to hold that section 117C applied. Well, of course, in my submission, it wasn't bound with IT Jamaica, whilst it had given some thought to the matter, had done so without adversarial argument. However, in any event, the Upper Tribunal here, in Williams itself, gives some thought to the matter. It gives dominant weight to 117A2B, which is the introductory section to the whole 117 regime, which referred to cases concerning the deportation of foreign criminals. So this tribunal very much takes the centre of gravity of the whole section 117C as 117A in order to hold that 117C applies in general to all deportation. It is, we consider, evident the present appeal concerns deportation of the appellant for the simple reason he is the subject of the deportation order. If therefore he were to return to the UK of his own accord, without executive or judicial authority, he would be in breach of that order. Accordingly, the reference to deportation falls to be read as covering the deportation regime whether before or after removal has been effected. Well, in my submission, that this reasoning doesn't deal with all the relevant points that could be made. It doesn't really give much attention at all, if any, to the forward-looking language of 117C. It doesn't give any attention to the inability of 117C ostensibly to comprehend the passage of time at all, let alone the 10-year proviso. And the other thing, it also doesn't alight on the prior regime, the regime that had been in force under the UK Borders Act 2007, which we saw, whereby there had been a distinct differentiation made for revocation orders, revocation applications made from abroad. And so in my submission, Williams is not a complete answer, although it's a presidential panel and may establish relatively persuasive points.
Would the court just mind also reading while we're here paragraph 29?
Just read it.
Several skips behind the beat.
It's quite graphic, but it does make a point.
Indeed.
I was going to ask Mr. Symes what his answer to it is.
Indeed, well, my point is simply the same one I keep referring to, which is that there is built into the rules the 10-year proviso, which means that you can't simply work the revolving door of its bearings by trying to come back very speedily.
No, but it's the point about the foot. It's Lady Justice Arden's point is that the rule wouldn't make much sense if you read it in the way that you're suggesting it should be read, and whether you work it off its bearings or not. Fact is, you've got to say, well, this rule's got to have some application in some courts, and it will be deprived of much of its efficacy if you don't apply it to revocation. That's the point that's being made. What's the answer to that?
The answer that I have is that for out-of-country applications, the last subparagraph of Rule 391 that you're referring to has a built-in equivalent of section 117C for early applications. Those applications must surmount the compelling regime.
Why should the compelling regime suddenly stop after 10 years when you've got a whole line of cases that say that the 10 years is a factor, but it's not an overwhelming factor? It doesn't actually make much difference in the overall scheme of things. We've seen all that authority, you've shown it to us.
Well, I'd say that EYF Turkey said that it was an open balancing exercise, not a weighted balancing exercise. When they came to look at that's how they summarised the case-by-case clause within 391 as it was eventually amended. In my submission, that's not consistent with a weighted balance regime, such as that which section 117C introduces.
But suppose you're right, and all that's relevant is looking at the length of time for which the deportation order has subsisted. We're dealing with the human rights appeal. What considerations are relevant in a human rights appeal? Because you're not giving us any. I'm not really understanding how a decision maker goes about deciding whether or not to revoke a deportation order if all that applies is the rule that you rely on. does a tribunal on a human rights appeal approach such a decision?
Well, my first proposition is that, as per Hisham Ali and various authorities, a policy struck by the rules can inform the human rights balance of exercise. And I maintain that there is a policy imperative found within 391, which is the case-by-case consideration after 10 years only makes any sense if it is free from being subjected to any weighting. And 117C is a weight-inducing.
That still doesn't answer my lady's question with respect. I mean, yes, all right, you take away the weighting. How do you go about making the decision?
Well, by reference to the Rule 390 factors, which are the considerations leading to the original expulsion, the compassionate circumstances, any representations made. That's the provision which indicates the general scope of inquiries under revocation.
It's always tantamount to saying that once you've served out your 10 years, you don't consider really anything to do with the offending or the public interest anymore.
Well, my case is that the first tier tribunal, Judge Brannan, got things right on that score. He did not leave that out of account, but he simply said that the lengthy period of time served by living out the 10 years abroad significantly diminished the public interest side of the scales.
I mean, just standing back and looking at this case, it's a fairly weak Article 8 application, always was. Leaving aside all the deportation side of things, this applicant really didn't have much of an Article 8 case at all. Never been lawfully in the country, out of it for a very long time. Wife and children here, adult child, no longer dependent, both independent financially. You start asking, what's the disproportionate interference with his family life? Answer, very difficult to find one.
Particularly since the FTC also found that his wife would go and live with him in Vietnam. It just seems, what I'm trying to understand is, how is a decision maker supposed to go about making a decision like this in a case like this if all they can look at is paragraph isn't the decision maker entitled to look at the strength of the Article 8 claim? And are you saying no weight is to be given to the fact that he's been convicted of an offence and deported? I'm just trying to understand what structure you say should be applied in making a decision like this.
Well, my case is the FTC carried out a model exercise in that it did not leave out of account. I mean, it did say that Section 117C didn't apply, but then it also included in its consideration various public interest factors, including compliance with the original deportation order, with staying abroad for 10 years. It found that the appellant was rehabilitated. It was alive to the issues of deterrence and public confidence in the system, but said that those were really answered by having gone abroad for 10 years and already suffered a decade or more of disruption of family life. So in my submission there are
Family life which was established at a time when he had no right to be here. This is the problem. He was in the country unlawfully all the way along. So disruption or no disruption, I mean, you don't normally get extra brownie points for coming to the country unlawfully and establishing a family life. Usually the rules say that very little weight is to be attached to a family life which is established in disregard of the rules.
Well, I fully hear all the points the court is making to me here, but I mean, but
and of course, I appreciate, Mr. Symes, that you're answering my lady's question, which is how do you go about it, and you're doing it by illustrating that by what the First Tier Tribunal did. What the First Tier Tribunal did is neither here nor there now. We're only concerned with the Upper Tribunal.
To be fair to Mr. Symes, he was answering my question.
He was answering it, yes, I know. and I think I said that to him, but it's. You say it's just a general Article 8 weighing up, but you do take into account the fact of the deportation and the fact of the criminal offence as part of an overall balancing exercise.
Yes, indeed. I mean, the language of Article 8, which the court is speaking, and I can easily say, you hear it all the time in my normal work, is born of cases which do not involve someone having gone abroad for 10 years and complied with the deportation regime. I mean, I completely recognise that this is a rather faint Article 8 played in the first place.
Yeah.
But it's not, I mean, no one's actually, overtly anyway, made a perversity challenge to what the FTTs had done.
This does slightly point up the importance of us knowing whether, if you're right on section 117C, what we're left with is the FTT's decision, not having been set aside, or we're left with the UT's remade decision, or have to do it ourselves, because if it's a weak Article 8, makes a lot of difference whether the FTT's decision is left untouched or whether it's gone. Doesn't it?
It's gone.
That was a point you wanted to come back to. Can I just say that looking at Rule 390, one of the factors expressly referred to is the grounds on which the order was made. So that would enable, or require, if you were right, the decision maker to look at the original conviction and the circumstances of the original offence.
Yes, indeed, exactly. The ground, 390 Roman numeral 1 precisely focuses on criminality because it looks to the order. Most orders will have been made on criminality grounds. 390 Roman numeral 3 looks at a slightly broader public interest, including effective immigration control. So the fact that this appellant had been in the UK unlawfully originally would definitely work its way in to 390 under 390.
It would surely work its way into 117B because I think you've accepted that 117B applies.
Yes, indeed, yes.
And 117B little 1, effective immigration controls in the public interest. 11B 4B little weight should be given to a relationship formed with a qualified partner established by a person at the time when the person is in the UK unlawfully. So even if the weight to be given to the deportation order and considerations in favour of the deportation order is reduced, there's not much to say against it.
Well, I mean, the rule simply posits Roman numeral 2, any representation made, and I suppose that would encompass whatever it was as an applicant for revocation.
He's very
was to
sorry
say.
that he did what he did, and he's a reformed character and all that sort of thing, which is what the FTT took into account.
Yes.
But what it really boils down to, I think, is that you're saying that if an application is made prematurely, by which I mean within the 10 years, then all the weighted considerations fall into play. And you can't really get anywhere unless you can show very compelling circumstances, etc. But the minute you pass the 10 years, it's back to a standard Article 8. That's really what it amounts to, without any weighting.
Yes, I mean, that is my submission.
I think that's really the bottom line, isn't it?
I mean, that's
Just
what,
to simplify it.
yeah, that's what EYF Turkey would suggest, in fact, by saying that there was an open balance.
And what weight, if any, is to be given to the fact that the deportation order has been made and still in force, and the underlying criminality which led to the making of the deportation order?
Well, in my submission, the decision maker, both the Home Office decision maker and the judge on appeal, should be looking at the public interest side of the balance. So they'd be looking at.
No, I know they should be looking at it. I'm asking you whether they're giving it no weight or whether they're entitled to give it substantial weight.
Well, that if if there were no rules or statutory provisions addressing Article 8, these say sharp, then simply on the Strasbourg authority, we'd know that criminality had to be taken seriously. And so one would be driven back to the Strasbourg threshold, and one would have to look them up, I suppose, but those cases that talk about long resident aliens, for example, long lawfully resident aliens having very strong cases, for example, and shorter resident, unlawfully resident aliens having weaker cases.
That would come in on your case under in the light of all the circumstances, is it? Rule 390.
Yes, yes. So, I mean, that really deals with everything I originally had to say on my first ground. But now I acknowledge.
Can I ask you one other thing,
Yes.
which is, when we were looking at Part 5A, you said that Section 117C didn't apply at all. But you could apply 117C1 and 2, which says that deportations in the public interest, the more serious the offence, the greater the public interest. Without applying 3 and 4. In other words, it might be only 3 and 4. It's 3 and 4 which you really need to say is only forward-looking. Isn't it?
Yes, indeed. I mean, 1171 and 2, and I know the government like harping on about 1171 and 2, but the reality is that those provisos would be found in Article 8 on any consideration, whether or not it was expressed in Article 7 in Section 117C. But yes, you're quite right. The force of my submission is that it's only the forward-looking provisions in 117C that don't apply to revocation applications from abroad. 1 and 2 are not forward-looking provisions, and in fact don't speak to that. They speak to more general issues.
But then the problem that creates for you is that the statute tells us that deportation of foreign criminals is in the in the public interest, and the more serious offence, the greater the public interest. So you've got, if you're looking at a pair of scales, which may be the wrong metaphor, I think, you've got something quite weighty on one side, and on the other side you've got the fact that the deportation order is being enforced for 10 years and a very weak private life, family life.
Yeah, I mean, I accept that analysis as far as it goes. I mean, it is only a 2-year sentence. Remember, I mean, it's not a +4 in terms of the hierarchy set by the legislation.
Yeah, but this isn't a relationship with a qualifying child established when the person is lawfully here.
Yeah, I mean, I've known all along that this appellant was quite lucky to win in front of the first tier tribunal. I get that, and I sit and take that as myself sometimes. I mean, I get that. But I mean, maybe it's not quite what you want to hear, but it's an absence of clear rationality challenge to what Judge Brannan was to say.
Yes, indeed.
I'm entitled to rely on the fact that the first tier tribunal judge did say those things.
Great history. It's an interesting part of the background.
Okay, so then we get on to the Upper Tribunal. We looked at what the Upper Tribunal said. Okay. So now I have to confront this issue, and I must admit I haven't really picked up on today about precisely what we'd appealed. Indeed, I understood, and I think perhaps over optimistically, that because the continuation hearing decision repeated the content of the error of law decision, that we had appealed both. That was how I had seen it hitherto. And now a potential view pressed upon me by the court at the start of today is that actually, unless we distinctly appealed the first error of law decision, I can't get to that point. The difficulty here is
you can. What you're not prevented from doing is, even if you haven't attacked the error of law decision, if you're right and the approach that the Upper Tribunal took in remaking was wrong in law, then you can appeal against that. But
It means it goes back to the Upper Tribunal and not to the first tier.
The position you want to get to is that the Upper Tribunal was wrong in law, should not have set aside the FTT decision, and therefore we're left with the FTT decision. And there is something in your grounds of appeal which sort of approaches that, if I can put it that way, in paragraph 10, where you say that
yes. I mean, the reality, of course, is I've forgotten what is effectively the universal practice. As I understand it, you cannot appeal an error of law decision until the continuation.
Correct. The
Is that
time
right?
scale. The time scale is changed. So you have to wait until when both decisions have been made in order to challenge them. That's true.
so the intention. So is this right? That you couldn't have appealed the error of law decision by itself.
That's correct. Yes.
What's the authority?
Well, I'd have to look up. I mean, it's like, but we. I mean, we. If you know what, if immigrant, you know how litigious immigration practitioners are. If they could appeal that,
I'm beginning to understand.
you can do even more of this than you already do.
I think,
No.
the answer, I think the answer to my lord is that
Not only the better
I
answer,
think
the more formal
technically you can, but you don't in practice, because what normally happens is you wait for them both, and the convention, or certainly the way in which the immigration upper tribunal rules are read in terms of timing, is that you're not out of time for appealing against the first decision if you wait until after the second decision. So you do. So the practice is that you do them both together, but you still have to do both. Or at least that's my understanding. But you might want to disabuse me of that. But I always thought if you want to appeal the error of law decision, you've got to appeal it separately.
Well,
May do it at the same time.
I mean, the Upper Tribunal doesn't make an order, does it, in the way the court does, but it does encapsulate in the written decision, but it encapsulates its decision. And I'm looking at page 105, which has at the end of what I would call the decision, reason, notice of decision, and that recites that the making of a decision did involve the making of an error of law, and it has been set aside, and it's remade and is dismissed. So, is your position that really by appealing this you've appealed all of that, including the setting aside of the first tier's decision? So that's the position you want to get to.
Well, that's where I had hoped until this morning. That's where I always thought I was going. That at least I hadn't seen as being a problem. I mean, I always understood that the continuation decisions in the Upper Tribunal always wrap up the error of law decision within them, and therefore, when you challenge the continuation decision, that was the procedurally correct moment to attack both.
Well, if we're going to be pedantic about language, and forward-looking and backward-looking, it seems to me that decision has been set aside is talking about something that's already happened and not part and parcel of this order.
I mean, I do this work for a living yet. I've sensed that we're swimming in quite deep water on this point. I wasn't expecting it. I suggest that, I mean, if this is going to be a thing in the final determination of the case, it would be better to permit the opportunity for short written submissions on the point, because the statutory jurisdiction of the Upper Tribunal is something you could write a book about it.
Yeah, but to be fair, if one looks at section 5 of the appellant's notice, it's true that the section 5 refers to the decision promulgated on the 8th of March, but it goes on to say whereby he set aside the previous first tier tribunal decision and remade the decision. So, from a more generous reading, it might be true, but both parts of the the upper tribunal's decision-making process are being challenged.
Well, that's my submission, that the tone of the grounds, e.g. paragraph 10 and section 5 of the appeal form, indicate
Not the
that
tone, maybe the language.
Well,
The body language, no,
The
the
mood.
actual
The
words.
tenor of the application is such. Yes.
so that's my that is my case then on ground 1.
Yeah.
So ground 2 and ground 3 can be dealt with much greater expedition.
So just so that I'm entirely clear, your position is section 117C, at any rate, subsections 3 and 4 did not apply, therefore the error of law decision was wrong and the FTT's decision should not have been set aside, since there's been no challenge on rationality grounds to that's where you end up, and however fortunate your client might have been to have got it, that's what the FTT judge decided, and so that gets restored. Without any review of the Article 8 exercise that the FTT judge did. Is that right?
Yes, that's precisely it.
Yes.
And I have to accept, because I kind of had this pessimistic thought in the course early on today, was that if you were to find that the Upper Tribunal's decision was the focus,
Yes.
and that therefore the data shifted on from the
Sure.
FTT decision, I'd be in the modern rules. Now then, the modern rules don't have the 10-year proviso.
Yes.
And then you'd have a real problem.
Well, I'm not conceding anything, but
Yes.
but I'm just not going to say anything more about that
Yeah.
point.
And you are entitled to say that although the grounds of appeal, the Secretary of State's grounds of appeal from the FTT to the Upper Tribunal did run both an argument based on the rules and an argument based on 117C. The Upper Tribunal only seized on 117C, didn't deal with separate briefly. And there's been no response notice. So nobody's ever said, oh, well, and by the way, the Upper Tribunal should have dealt with the appeal on the basis of the rules as a kind of backup. And no one suggested, as you pointed out, that the FTT decision was perverse.
Yes.
Yeah.
Okay, so the second ground proceeds on the premise that 117C does apply. Okay, so that the UT was right, and therefore it would have been correct to overturn the FTT, and it would have been correct to undertake its own analysis. But we say that it was nevertheless incorrect in the outcome of what it did. And that's because, as we know from the authorities in general, whatever lens Parliament chooses to make judges look through, there must always be ultimately an Article 8 compliant analysis. And in my submission, Article 8 must require that all relevant considerations can at least be looked at, weighting aside. And the changing nature of the public interest represented by compliance with the deportation regime having gone abroad is something that should have been distinctly applied in the appellant's favour. And the only way of doing that, given that we would be in 1176 territory, i.e. the very compelling considerations clause, is to recognise that whereas in general across most of the field of deportation, we know that very compelling considerations is construed as unduly harsh with bells on. In this particular scenario, to countenance the full extent of the public interest, we would have to lower that threshold and recognise that a case simply is very compelling, where a person has complied with deportation and, in terms of the aspects of the public interest dealing with criminality, rehabilitation, deterrence and public confidence, a judge has found in their favour. And obviously, as we saw earlier, Judge Brannan's first tier decision was replete with positive comments made about the first tier tribunal, about the appellant in that regard, pleading guilty, speedy departure, etc., etc., etc.
Pretty thin grounds for saying that that's compelling.
Yeah, I mean, I understand why Lord Justice Arnold had less enthusiasm when Brian Burton on this one. Right there.
But one of the differences, if I remember rightly, FTT Judge Brown himself said we're nowhere near
Very compelling.
unduly harsh or very
In his,
Yeah.
you're quite right. He did say that in my submission. Because he didn't see my.
So although his analysis is in other respects entirely impeccable and to be lauded, in this respect he went wrong.
Yeah, and the label. So he didn't understand that very compelling and indeed unduly harsh could simply be needed to take account of the full public interest, which would include all the positive points that he'd made, and so that whilst the language is expressive, it implies a very high threshold. In reality, it would have to move downwards. That's my second ground. I'm not going to develop any further.
Is that technically an application of the interpretive obligation of the Human Rights Act? We need to read section 117C in a way in conformity with the Act.
Well, I mean, I'll give you. I mean, it might very well be. I mean, I'll give you an example.
I just don't understand that anyway, because the whole point about, as I think the Supreme Court has observed, the whole point about the code in R5A is that it's supposed in most cases to reflect the Strasbourg jurisprudence, and so anyway.
Yeah, there are legal themes that don't run perfectly with my submission. I accept that. Yeah, I accept that. But I did want to before I just stop doing that altogether, just refer you to HARR because it does answer my lord's point.
Yes. Which bit of HARR?
So 352 is the kind of outset of it. Yeah, here we are. Paragraph 5. The very compelling circumstances test requires a full proportionality assessment to be carried out, weighing the intent of the rights of potential deportee in his family to private and family life under Article 8 of the ECHR, etc. So that is very. You have it in terms. I mean, Lord Hamlin in terms says that the residual 1176 very compelling circumstances test does require a full proportionality assessment.
Yes, but anyway.
Well, Anyway, leaving that then, and onto the third ground, failing to have regard to the terms of the immigration rules, but I can deal with this basically today. I think, as you will have appreciated now, it's my case that Judge Brannan in the FTT accurately addressed the content of the immigration rules, 391, etc. He looked at all the relevant considerations, and his conclusion was that the rules were met. And he even cited the authority, TJ Pakistan, which is the case that famously says that so long as family and or private life is engaged, then normally satisfying the rules will be positively determinative of proportionality. So this is really a rehash of the ground too. So when Judge Brannan said that there were no unduly harsh consequences or no very compelling considerations, he failed to take account of the fact that actually meeting the rules, even absent those considerations, should be enough to meet the
By meeting the
public
rules,
interest.
you mean waiting 10 years before you apply for revocation?
and having a successful assessment of the Rule 390 considerations.
Okay.
And so once again, he failed to appreciate that actually one could have, the mere fact of meeting the rules was sufficient for the appeal to be allowed. And that's all I really have to say on the third ground.
Meeting rules in this context is a proxy for, because it's a human rights appeal. How do I?
So the immigration rules are often said to express the public interest.
No.
And therefore, if the public interest...
Oh, I see.
is
Secretary of
so-
State's statement of the public interest, if he meets them. Yeah.
That's it, yeah, that's it. That's all I have to say on the third ground. Unless there's anything else I can help you with, that's the case for the
very much, Mr. Simons.
Very grateful to my learned friend for taking the court to various authorities and doing so very even-handedly. I was proposing to start by dealing with the legislation and the rules, then the case law, and then respond directly to the submissions on grounds 1 and 2, and then Miss Jackson will deal with ground 3. Could I deal with 3 preliminary points? The first of which, not unusually, involves me saying I was wrong. So if one looks at the decision in YM, and I will take further instructions on this over the lunchtime adjournment.
39.
So tab 11, it starts at page 86, and this is to do with the issue about which rules are relevant. The paragraph in YM Uganda is paragraph 39, and what the court says is normally it's the date of the decisions, but it then says the immigration rules are a statement by the Secretary of State of how she will exercise powers of control over immigration. Thus, in the absence of any statement to the contrary, the most natural reading of the rules is that they apply to decisions taken by the Secretary of State until such time as she promulgates new rules. The same applies to decisions by tribunals and the courts. That's why in MF, the Court of Appeal held that both the Upper Tribunal and it were obliged to apply the 2012 rules to MF, despite the fact that the Secretary of State had taken her original decision in 2010. So I think the point is, as my Lady Justice Andrews put it, which is because those rules expressed important public interest factors, the court had to look at those, and therefore on that basis it's not the pure or the Lola principle, because the court has to take account of where the Secretary of State says that particular weight should go. So that's that first point, but I will talk to my learned friend over the lunch break and see if we can get something more concrete. Now, the result, as my learned friend very fairly accepts, is that if this case, if he were to win and the case goes back to the Upper Tribunal, he must lose because the rules now have nothing about 10 years. Now, for all the reasons I'll give, we simply don't get to that point because he fails for other reasons. But that explains in my submission why he needs to cling to the first tier tribunal decision. Our case is that that decision is so shot through with errors that it simply cannot stand. So
Well, it may be, but the problem is, on what basis it was open to the Upper Tribunal to overturn the decision of the FTT, and if there weren't grounds of appeal raising the relevant errors, and or there were, but the UT didn't rely on them, where does that leave us?
well, it depends, I suppose, on what the court decides and why. So if the court is with me on section 117C, then the first tier's decision can't sensibly stand for the reasons that the Upper Tribunal gave.
Yeah.
If it's the hybrid position, which my learned friend submits it is, which is only bits of section 117C apply, the first tier tribunal has still gone wrong because it hasn't directed itself in accordance with section 117B.
Is that respondent's notice
Well,
or in the UT?
It's in the Secretary of State. The Secretary of State says about the decision of the first tier it's an error because it doesn't apply section 117 at all. So it's always been the Secretary of State's case. We weren't aware until today that my learned friend accepts section 117B applies. The Secretary of State's case, if I can invite the court to look at the core bundle, page 132. So although this is the Secretary of State's application for permission to appeal, unfortunately there's a flag on it, which means paragraph 11 can't be read. The Secretary of State, paragraph 4, says section 117C applies. Given that on my learned friend's case, section 117C is the bit that doesn't apply. A submission that section 117B applies necessarily encompasses a submission that the whole of Part 5A applies. So the Secretary of State obviously is picking up on section 117C, but the first tier finds that section 117C doesn't apply at all. So
Yes, but this does it refer to 117B and say, here's another error the FTT made, which it didn't apply that little weight should be given to family life when your presence is unlawful.
it doesn't say that in terms, although in my submission,
Does it say it implicitly? Because it doesn't look to me as if it doesn't say it expressly, it's difficult to say it says it.
well, paragraph 11, I can't read a bit of it because there's something over the top that fail to have regard to the fact that
Something.
does not extend to offering a choice as to where family or private life, if it's found to exist, is to be enjoyed. In my submission, that's a plain reference to broader Article 8 considerations than those simply in section 117C, because that's picking up the well-known principle that Article 8 does not permit somebody to live in a state of their choice. And that underpins section 117B, so it is there in my submission, apart from the flag over the top, but I think it's clear what it's saying, even with those words obscured.
So do we read that as have regard to the fact that Article 8 does not extend to offering a choice,
Yes,
and even if found to exist?
yes, we will get the unobscured version in case it says something completely different, but on the face of it, that is what it's saying.
That's a different point from saying little weight is to be given to family life developed when you're here.
It's the umbrella, and your lordship's point is underneath the umbrella, if I may put it like that. The umbrella point is about family life and basically couples not having a choice, not being able to insist that they can live in a state of their choice. And below that are various principles which one wouldn't, in my submission, expect to see enunciated and what are effectively or ought to be short grounds of appeal.
Did you two do with any of this? I don't remember it doing so.
In the sense of dealing with little weight being given to precarious family life, in effect.
In the sense that when setting aside the FTT's decision as involving an error of
In the
law,
first.
it concentrated on the application of section 117C. I don't remember that it made any other. There were any other grounds on which it set it aside.
Paragraph 14, page 117,
Yes.
the judge was wrong to have concluded that Part 5A of the 2002 Act, which of course included section 117C. So the Upper Tribunal is taking a broader point about the entirety of Part 5A. It's just that the bit that everybody naturally is honing in on is section 117C, because that relates specifically to deportation, but its reasoning is not limited to section 117C.
And actually, some force is given to that by the way in which the Rule 24 response was dealt with. If one looks at 116, paragraph 9, any error made by the judge in terms of Part 5A of the 2002 Act was immaterial.
Yes. And certainly, in my submission, nobody at this level would have been approaching it on the basis that section 117C was somehow to be excised from the broader context of Part 5A in which it appears. The question that would have been in everybody's minds is, does Part 5A apply or not? At that point, nobody had suggested, indeed they hadn't suggested until today, that part of it could be excised and not all of it. So it's, in my submission, given that, it's perfectly reasonable for the Upper Tribunal to have said the whole of Part 5A applies, which of course includes section 117C, and not to have anticipated a slightly more obscure point that a bit of it could be pulled out and applied on its own.
Yeah, so the level of the presenting officer who's settling the grounds of appeal is the deputy and the other considering the grounds of appeal, it will be understood that what was at issue was whether Part 5A applied rather than simply 117C.
Precisely so, my lady. So nobody would think, although interestingly, as I say, paragraph 11 makes a broader point, but nobody would have thought to say all of Part A, bits of it can't be stripped out. And indeed, one's dealing with a decision of the first tier, which said all of section part of 5A doesn't apply.
Yes, and in fact, 5A is referred to in a sort of blanket way in paragraph 14. The error of law reasons as they are mirrored, if you like, in the decision, page 117, paragraph 14.
Yes.
The judge was wrong to have included that Part 5A of the 2002 Act, which of course included section 117C.
Precisely.
To cases about alternative going to establishing that these provisions do apply, plural,
Yes.
set out in Binaku.
Yes. Exactly.
And that's why the concession was made.
So, albeit with considerable ingenuity, my learned friend is making different points today. Certainly the basis upon which everybody was operated was this is all about the whole of Part 5A, and that's the basis on which the judge has set aside the decision.
Well, I wonder, I'm just looking at the FTT's decision. The FTT judge doesn't say none of Part 5A applies. The FTT judge concentrates on section 117C.
Well, if in my submission, just turn that.
The submission that he's dealing with is at paragraph 35 on page 150.
Yes, that's
And in fact, it was a fallback submission because Miss Records' primary submission, we can see at 32, was that exception 2 was met because it was unduly harsh. But the submission, as recited at paragraph 35, is section 117C does not apply to revocation. And it's that which he then goes on to say is a question of statutory construction, which
yes, that's fair.
he engages in, and his conclusion is that at 38, an application to come back appears not to be covered by section 117C. I don't see there any reference to other bits of Part 5.
That is true, although they are omitted. In other words, one might say section 117B being a statutory provision which was relevant to this case was Robinson obvious and ought to have been addressed by the first tier tribunal. In other words, on his own reasoning, okay, I'm not going to apply section 117C. There's no reference at all to section 117B. And in my submission, I entirely accept what your lordship says, but there is no reference here to section 117B. And as Lady Justice Andrews and Lady Justice Elisabeth Laing pointed out in argument, it is directly relevant and it's not here. So in those circumstances, it can still be an error for the first tier tribunal not to have applied it, and the upper tribunal was entitled in my submission to say it didn't apply Part 5A at all, including section 117C, because there is nothing in this decision to show that section 117B was applied.
And permission to appeal was granted on an unlimited basis as well. According to paragraph 7.
Yes. So in our submission, particularly given that the basic understanding, and as I say, putting aside my learned friend's ingenuity in trying to split off bits of section 117C, the basic way that everybody proceeds and was proceeding is that it's Part 5A that applies. And the first tier doesn't, for example, say, as it ought to have done if it thought there was a reason to only disapply section 117C. First tier doesn't say, but I'm going to apply section 117B but that doesn't matter because, indeed, it does the opposite on its reasoning, as your lordship pointed out. It says none of this is very compelling. So I'm afraid, not only for that reason, but for many others, when one reads it, the First Tier Tribunal's decision is wrong in a number of respects, but all the Upper Tribunal needed to do was identify a material error of law, and that material error is the lack of application of Part 5A at all. So that was my first point, was a different point, which was about the rules in force. And as I say, I will discuss that with my learned friend over lunch. The other two preliminary points, the second was in relation to when you can appeal an error of law decision and not a second decision. There is authority on that. I don't have a signal to be able to get into it, but I can check that over lunch, and we can give the court chapter and verse. The third preliminary point relates to the provisions in the rules on suitability in relation to entry clearance, and that my instructions is that where the offence is, the sentence was for longer than 12 months but less than 4 years, that it isn't a bar where a period of 10 years has passed since the end of the sentence in the suitability requirements.
Does that mean it can be taken into account? Or does it mean it's irrelevant? Because there are two different things.
Yes, it's not taken into account under suitability. Whether it can be
not taken into account at all.
Under suitability, so the relevant section is section SEC, suitability entry clearance, and that's a provision about refusing entry clearance on grounds of suitability if certain conditions are satisfied. The condition won't be satisfied, so there is no mandatory refusal on grounds of suitability. What I will check is whether there's some sort of discretionary ground.
Yeah, because sometimes there are discretionary grounds of refusal.
Indeed, there are.
It's not a mandatory ground.
It's not a mandatory ground. So after that, from my perspective, scrappy start, for which I apologise, but these are tricky points in relation to the procedure. I see the time.
Yes, would you like to have a fresh start at 2?
Yes, and I'll move then on to the legislation and the case law and so on, and we say really all of that is straightforward. So I'll take that as briskly as I can after lunch.
Good. Well, thank you.
Court rise is able.